Today, we are going to dig into a law from the 17th century. It's a legal fossil, really, but one that can still reach out from the past and completely destroy a modern contract. Okay, just picture this for a second. You've signed a huge contract. Maybe it's for your new house, maybe it's a business loan. You file it away, you think everything's safe. But then, without you ever knowing, a total stranger finds it and changes just one important word. All of a sudden, that whole agreement could be totally worthless. Sounds like some kind of crazy meetup scenario, right? Well, it's not. In the legal world, this actually has a name. It's called the officious burglar problem. And it is a very real thing, all thanks to a very, very old rule. So let's talk about this officious burglar. It's not just a quirky legal term. It's a doctrine that can have some pretty devastating real-world consequences. Here's the heart of it. If a material change is made to a written contract, after everyone has signed it, the whole document can become void. And I don't mean voidable, I mean, gone. It discharges everybody from their obligations, like the contract never even happened. And the truly wild part, it doesn't even matter who made the change. So what is this legal ghost that's haunting our modern contracts? Well, to find the culprit, we've got to go back in time. And I mean way back. To really get this, we have to transport ourselves to 17th century England, a time when the legal world looked completely different. Yep, 1614. That is the year this rule was officially put on the books. Just let that sink in for a minute. This legal doctrine is older than calculus. It's older than the city of New York.
Now, to understand a rule this old, you have to get into the mindset of the time. Back then, a legal deed wasn't just evidence of an agreement. It was the agreement. The actual piece of parchment, the ink, the wax seal, that was the literal embodiment of the promise. The famous legal scholar Oliver Wendell Holmes called it a primitive notion. If you physically changed the document, you were changing the obligation itself. And this whole idea got cemented into law by the legendary jurist Lord Coke. The case is now famously known as the rule in Pigot's case. And it's a simple but absolutely brutal rule. If you materially alter a document after it's been signed, you risk making it totally void. And Lord Coke was incredibly specific about this. He laid out 3 key points. First, if the person who stands to gain from the contract changes it in any way, even a tiny, insignificant way, the whole thing is void. Second, and here's our officious burglar, if a stranger messes with it in a material way, it's also void. And third, if a stranger makes a tiny, immaterial change, then, okay, the deed is safe. But, of course, a rule from 1614 doesn't just stay frozen in time. Over the next couple of hundred years, the court started to stretch its reach, way beyond what Lord Coke probably ever intended. You can really see this rule's mission creep over time. It started out in 1614 just for those super formal, sealed documents they called deeds. But then, in 1791, it expanded to cover things like checks and promissory notes. The really big leap, though, was in 1844. The case of Davidson v. Cooper applied the rule to all written contracts. Suddenly, a rule made for parchment and wax was governing modern business deals. So where does that leave us today? Well, the focus has kind of shifted. It isn't so much who made the change anymore. The big question is whether that change was material. And what does that mean? The modern test is pretty straightforward. A change is material if it has the potential to mess with the legal rights or obligations of one of the parties. Okay, so we've got this ancient rule that's been stretched and pulled to fit our modern world. But does it actually work? Does it make any sense today? Let's break down the original reasons for this rule and see if any of them still hold up. Spoiler alert, they really don't. Okay, argument number 1. The rule is a great way to stop people from fraudulently messing with documents. And, that sounds reasonable. If you mess with a contract, you lose everything. But is that really the best way to deal with fraud? The difference is pretty stark when you look at it. The rule in Pigot's case is a sledgehammer. It just voids the entire contract, punishing the innocent party just as much as the guilty one. Modern criminal law, though, it's like a scalpel. It targets the actual person who did the wrong thing with specific, proportionate penalties, like, up to 10 years in prison. We just don't need this ancient rule to punish crime anymore. All right, on to the next justification. This one's all about evidence. The idea was, back in 1614, if your only copy of a deed got altered, you might lose the only proof you had. So the rule was there to protect that single, sacred piece of paper. But that world is just gone.
In the 17th century, they had one piece of parchment. That was it. Today, we have photocopies, PDFs, scans, cloud storage, duplicate originals. We have a million ways to prove what a contract originally said. The idea that we need to blow up a whole agreement just to protect its evidentiary value is honestly just obsolete.
And this brings us all the way back to that core foundational idea, that primitive notion that the physical paper is the promise. Does that concept have any place at all in modern law?
Nope, not really. The whole way we think about law has shifted. The primitive notion was that the paper is the deal. But the modern view, which is the basis for all of contract law, is that the paper is just evidence of the deal. The real agreement is the meeting of minds between the people involved. The paper is just the record of it. So the original reason for the rule has completely fallen apart.
So if the rule's original justifications have evaporated, and all it does is cause injustice and confusion, what's the solution? Well, it turns out legal experts have a very clear answer. I mean, it doesn't get much clearer than this. After taking a long, hard look at it, the New South Wales Law Reform Commission, a group of experts whose job is to improve the law, came to a very direct conclusion. Get rid of it. Abolish it by passing a new law.
And they even laid out a simple 3-step plan to do it. Step 1, pass a law that just says the rule is abolished. Done. Step 2, make it clear that an alteration by itself doesn't kill the contract. The original terms are still valid. And step 3, make sure this doesn't stop someone from using other legal tools, like suing for fraud if someone actually did something wrong. It's a clean, simple, modern fix. At the end of the day, the rule in Pigot's case is a total relic. It's a legal fossil from a time of quills and parchment that just makes no sense in our world of digital files and modern criminal law. It creates real injustice without serving any useful purpose anymore. And that leaves us with one last kind of spooky question. If a rule this old and this broken can survive all the way into the 21st century, it really makes you wonder, doesn't it? How many other legal ghosts are out there just hiding in plain sight?